This may be the most consequential free speech decision in the last 50 years when it comes to student free speech. The justices heard today. It deals with a 2017 case out of Pennsylvania. A teenager named Brandy Levy posted what's known as a snap on Snapchat online back in 2017, expressing some frustration when she tried out for the varsity cheerleading squad. She didn't make the team. Off school property, she posted on Snapchat, F school, F softball, F cheer, F everything. School officials saw the post, kicked her off the JV team. School policy prohibits foul language and inappropriate gestures by student athletes, even on the internet. But Brandy Levy's post was again made off campus after school hours.
I have the chance to show other people that are like me that it's okay to express how you feel and not get in trouble for it.
And Fox News reached out to the Mahanoy School District for an interview. The district declined. In a court brief, the district doubled down on the punishment, writing that by putting the message on Snapchat, Brandy was intentionally reaching a school audience. Today, the justices at the Supreme Court weighed in, seemingly defending Brandy Levy in some cases.
So maybe what bothers me when I read all this is that it didn't seem like the punishment was tailored to the offense. I mean, a year suspension from the team just seems excessive to me.
It might be that student speech that occurs outside of school is sometimes going to cause fundamental problems, disruption of the school's learning environment.
This is all about disruptive speech, Neil, and the implications could last for decades about this off-campus speech. What it means, we'll find out from the justices at the end of June, latest early July. Neil.
Thank you, David. To Seth Berenzweig right now, the business law attorney. What do you think of this case, Seth?
Landmark case. It'll be fascinating to see what they do. This is an issue that has really not been dealt with directly by the Supreme Court, freedom of speech for students, since 1969 in the so-called Tinker case, where the Supreme Court said that a silent protest with black armbands objecting to the Vietnam War was okay as long as it wasn't significantly disruptive. Now we jump ahead decades to the present, and now we're living in the world of social media. I believe that the Supreme Court will probably rule in favor of the student. They're going to be walking a little bit of a constitutional tightrope. On the one hand, if there is speech that is off campus, that is not disruptive, that is not something that would cause a likelihood of harm to anybody or cyberbullying, then that student doesn't check her First Amendment rights at the door. On the other hand, cyberbullying and certain activity online in or off campus is something that could really cause a very harmful environment. So I think Justice Kavanaugh, as in that sound that you played, showed that the Supreme Court will be careful, but will probably side on the side of the student. This is going to have big implications because this is the first time that this First Amendment constitutional issue is going to be echoed within the chamber of social media.
All right, Seth, I apologize for the brief time here, but thank you very much, Seth Berenzweig, on that. That's a case to watch.